Bruce.
Hey, Cheryl.
How are you?
Good. Getting people on board here.
Well, what'd you think about the election last night?
Quite interesting. They thought it would be not called for quite a while.
Well,
Suddenly
I
it
know.
is.
I,
Yep.
I was I was kind of shocked, I thought, I mean, to be honest. But did you see if the Republicans I knew they got one more Senate seat. Did they get another one? Do you know? At
They
the
got the
federal level?
Senate.
They got the Senate?
They are in control of the Senate and unclear yet on the House. But the Senate's a big deal. We'll talk about that in a minute.
Is a big deal.
So good morning, everybody. We'll be starting in about 5 minutes. Thanks for joining us this morning. You should probably rename yourself.
Oh, sure. We can't have two Bruce Wicks, can we?
That would be a challenge. One's enough, right? Morning, everybody. We'll start in about 3 minutes. Hello, Cheryl. You can see my screen with the PDF up on it. Okay, thanks.
Sorry, you couldn't hear me. Yes, I can. No problem.
Great, thanks. Morning, everyone who's just joined. We'll be starting in about 2 minutes. Thanks for joining. Well, good morning, everybody. We're gonna head out here. Thanks for joining us for our annual New Laws webinar. And we have a lot on the table here, but we want to start with two quick things. One is the annual or the 25th anniversary of our association, battling in an ever hostile California environment. So we're going to take time November 21st in Southern California to have a anniversary, and it's going to be a fun time. Cheryl, are you there where you could describe the MC? There's not going to be a lot of speeches. It's just going to be a fun thing. And Cheryl Marcel is our executive director, and she was on a minute ago. Hopefully she'll be back in a minute, but it's going to be a fun event. We invite everybody to participate. You've gotten several email notices about it. It's just a great time to stop and just take stock of what we fight for, why we do it. And our MC has a little comedy, he does a little magic. It's just going to be a fun celebration. And obviously, before we get into California, significant events on the national side last night. Some still up in the air, but obviously we have a new incoming president, and a very important thing for us is the Republican Senate. In the previous administration, President Trump had a hard time getting appointments of key people, and it matters to us. We have right now two significant things going on. The federal government has pushed on or towards us, and one is in our Advanced Clean Fleets regulation by the Air Resources Board is in the federal EPA waiting for a waiver. And if President Trump, when he takes office, can quickly get a new EPA secretary appointed, they could decline the waiver and possibly kill that overdone regulation, which affects our larger members. And as well, fault protection for roofing and framing contractors. Federal OSHA has pushed on us an unsafe and unworkable or really problematic regulation for residential construction. They're going to move on commercial construction next. And if we get a new OSHA chief appointed, possibly those could be turned around. So we're hopeful that some things on the federal level will matter. On the state level, some races are still a little bit too close to call, but we do think we've made some real progress. As you know, our U-Turn campaign is trying to identify, winnable races for Republicans and moderate Democrats. And we've not had 51% in either the state Senate or Assembly to kill bad bills. And it looks like we might actually get there this time. A couple races are too close to call, but our contract lobbyist, RJ Cervantes, does a great job battling in the Capitol in offices on the floor to promote good legislation, defeat bad ones. But he also does a great job recommending who to support. We utilize our money very carefully that you contribute to our PAC, and we have good news to report. So right now, there are 18 Republicans in the Assembly, 80 people in the Assembly, 18 Republicans, two, their races are too close to call, two are in the lead, two, they're slightly behind, but still could possibly win. So we will likely either have 20 or 22 Republicans in the state Assembly, which is a pickup of 2 or 4. That's great. We also look like we will pick up 2 or 3 moderate Democrats instead of progressive or liberal Democrat. And what that means is the way that could work, we could have 41 votes in the Assembly. The Republicans always vote for business friendly, common sense, either opposing bad legislation that way or supporting good legislation. And the moderate Democrats aren't a pure voting bloc, but they all listen to business views on common sense things that help business or detrimental to business and employees. So we might have a 41 vote in the 80 House Assembly, an ability to kill all bad bills. That's a really, really big thing. So it's not clear yet, but we're hopeful. That would be a major improvement. Thank you, all of you who contributed to our PAC. It really does help. So if you have questions, please put them in the chat, and we will monitor as we go, as we start talking about what happened in California in the 2024 legislative session. So here we go. As you know, we review any bills that can affect contractors or suppliers of contractors. Those are our constituencies. So there's over 2,000 bills floated every year. We look at those ones that could impact us. There were about 350 we reviewed. We monitor 245. And then we have our 6-person Government Affairs Committee. We appreciate their hard work. We meet twice a month during the legislative year and take positions on bills, decide which to support and oppose. And again, our contract lobbyist does a great job going after those bills. So of our 20 supported bills, 5 became law. That's kind of normal. That might improve if we get an assembly that can push bills through, although the state Senate is still a little behind on a business-friendly majority. The governor vetoed one bill because there was a companion bill that we had supported, what we thought was a better bill, but he went with the other one. And so that wasn't like saying we had a bad bill. He just thought one was a little better, and we disagreed. We opposed 42 bills, and out of those, only 8 became law, less than 20%. That's a really effective year. Obviously, we work in coalition with other parties, so we can say, we had a pretty good year. The governor did veto 5 negative bills, primarily due to the expected cost of them with the budget issues the state is having. So we're going to review 36 bills that could have an impact on our members. A few you'll need to take some action on. Others you just need to be aware of, be prepared for if something comes at you. So that's where we're going to head this morning. And then, I do want to reiterate what a great year this was for PAGA reform. As you know, PAGA stays, but the impact on good employers, if you take the proactive steps, has been reduced over 90%. That's a great win. And I know I've attended several attorney webinars where they're pretty lukewarm about it, but I think they're not looking at the big picture. Labor finally came to the table because they realized out of the huge PAGA payments and settlements, very little went to employees. And they realized the labor commissioner and plaintiff attorneys were very ineffective going after truly bad actor, serial violator employers. And they wanted to be able to do that. So PAGA reforms gives them more tools to go after bad actors, but they have to show evidence, proof. And so for our members, labor is not going to be pursuing you. They're going to be, thankfully, pursuing the truly bad actors that we don't want to compete with. And those that take advantage of their employees. And plaintiff attorneys really went for 2 things. They want to go after the big 5, 10, 50,000 employee firms who still don't have their full act together on labor laws. And they can get these 10, 20, $30 million settlements. If we are doing our job right, we're not going to be a target. And their other target is pay stub violations. And out of 1.4 million California employers, they're going to have probably a never-ending supply of people that just on the face don't have a compliant pay stub. So if we get those things done right, and yes, an employee can say, hey, I worked off the clock, so the pay stub was incorrect. But if the pay stub on its face is good, those plaintiff attorneys are not generally going to go after us. So PAGA reform was a big deal, and we need to celebrate that. So as we go through these 36 bills, unless otherwise noted, they take effect January 1, 2025. And the link you see shows you how the bill changes current law. Where it establishes a brand new law, you'll see it all in blue. Where a law has been amended, you'll see that part in blue. It's much easier to read that way. So as we go through and later on, as you're looking through this, you can just go to that link. Because if you look at the law itself, they just go on and on. You don't know what really changed or what was there. So we're going to look at labor laws first, and we'll go through several of those. And one of the other reasons we want to have a majority of business-friendly legislators is the unfair tactics some Democrats do and get their leadership to go along with to pass bills. And they do this two ways. One is they do a late gut and amend or a late amend. And as you know, most legislation really needs 45 days to go through the legislature and be vetted. It needs to be noticed and go through at least 2 committees in each house, be noticed and go through the floor in each house. And that really is about a 45-day process, to be fair. But what they do is they wait until the very end of the legislature and get their leadership, the Democrat leadership, to sign waivers saying we don't have to follow the law. And boom, we get these late things that you really can't mount any opposition to. So this is where if we can get a consistent 41 votes against on the floor of the assembly, they won't be able to do that anymore. They'll just be defeated. They'll actually have to come earlier and show their cards and allow us to do a reasonable opposition to bad bills. So this first one, example of that, with 10 days to go in the legislature. As you know, in construction, union employees cannot file a PAGA claim if their collective bargaining agreement covers what labor laws and PAGA declares they should. And they got that extended from 2028 for another 10 years. So as we know, part of the PAGA reform is PAGA remains in place, and union contractors whose collective bargaining agreements cover it will still be exempted now for a longer term. This didn't need to be a late gut and amend. They should have been debated fairly in 2027. How does this work? But this is one of those things that happens. But again, a major part of the PAGA reform is where before a union could go to a non-union employer and say, we're going to try and organize employees. We'll help them bring a PAGA claim every year. And previously, the PAGA claim potential was huge. Now that can be reduced over 90% for a proactive employer, that leverage is much less. So union contractors still have protection, and they will, against PAGA claims entirely, but merit shop contractors don't have to, they have to deal with PAGA claims, but on a much less basis. So AB 1888, we just need to be aware of this, establishes in a labor trafficking unit. Obviously, tracking is a terrible thing. We don't want it. We oppose trafficking of people in labor and otherwise. The question is, this now will have a unit in the California Department of Justice. The Attorney General runs the Department of Justice. And while none of our members are going to be involved in trafficking, what can happen, obviously a new unit wants to make a name for itself in the Attorney General's office, and they are required to coordinate with many other state agencies like Labor Commissioner, EDD, Cal OSHA. And all it takes is an inspector from one of those agencies to refer for a possibility to this new labor unit. And they're going to come investigating, and Department of Justice people have very big badges. They can they can do whatever they want. So if you happen to be in the wrong place at the wrong time and someone from the labor trafficking unit shows up, no, this is serious, and we're going to be able to exonerate ourselves and have them not pursue us much farther. But understand, this is a big deal. They're going to want to make some big hits early, so we need to be careful. Then, as you know, there's the state family temporary disability insurance leave program. It's funded by employees, not employers. A concern of ours is that they keep adding benefits without increasing funding, and someday they're probably going to try and turn to employers to start paying for this. We're trying to avoid that, but an employee who is making a claim to this program right now, an employer can require the employee to take up to 2 weeks of earned but unused vacation before they apply to it. I don't think most employers do that, but if you do, this bill will say you can no longer require that, effective January 1. AB 2299, as you probably are aware, whistleblower claims where an employee complains to OSHA, the labor agency, or some other entity that their employer is violating the law. They are protected by whistleblowers and as whistleblowers, and there's been some pretty serious reinstatements, back pay, penalties for employers when that's been proven. So, our members are hopefully not going to be in that position, but we can get some protection here. The Labor Commissioner is supposed to post a model list that we can then post, and with larger than 14-point type and phone number of the whistleblower hotline. And that at least gives us posting clearance and will be a good step forward to say, hey, our employees, we're not worried about them doing whistleblower stuff. Unfortunately, the Labor Commissioner has not yet provided that model list. As soon as they do, we'll ship it out to everybody. It will need to be posted by January 1. In AB 2696, well, this won't likely impact us much, but we do need to be aware of it, especially when we hire a sub-tier contractor. As you know, some of the unions, especially the carpenter union, push for the ability to go after a general contractor who has hired a subcontractor who is behind primarily on benefits owed to the union, and to be able to squeeze the general contractor for money owed to the subcontractor. But they realized they didn't allow themselves to sue if the direct contractor, the general contractor, was union as well and behind in benefit payments. So they're adding the direct contractor. And while, again, our members are not generally general contractors, if we are contracting and have a sub-tier contractor, they could theoretically go after us if they were benefits or wages due by us, try to do that. So hopefully this will not affect us at all, but just so you're aware of it out there. And AB 2738, and this is another thing, sadly, some of the Democrats do, is they file kind of an outrageous bill, and then they gradually piecemeal amend it, trying to get more Democrat votes until they finally get enough. And this bill is one of those. It was amended 5 times, and it isn't like you can sit around the table with the legislator and say, hey, let's fix this thing. They just give you incremental little changes, so they finally get enough votes for it. And this brings up an issue that we are concerned about, that our members need to be aware of, and why we want them to be And again, being proactive to minimize PAGA claims, um, we hopefully will have very little labor law violations. But in local jurisdictions, you can have environmental groups, worker advocate groups, sometimes unions, sometimes city council persons who want to favor certain contractors. So they can try to mobilize their um, staff, their city attorney, a district attorney to go after um, someone, an employer. And, we're more susceptible to this because we're often out of that city or county domiciled and we're trying to do work in that city or county. And if someone's trying to protect someone else, that can be a problem. So they're trying to ramp up the ability of local people to prosecute claims, both labor law and discrimination. We'll talk about that more in a minute. The law previously said that if they can do this, and a court may award attorney's fees and costs. Now, this bill says that's required to have the prevailing plaintiff party, not prevailing party. Either way, it's only the prevailing plaintiff that can get attorney's fees and costs. So this is where, a city council person or a county supervisor can say to their, fellow people, this won't cost us anything to go pursue these labor law violations because we'll recover our costs. And so it's a challenge. And again, we need to be careful when we're going to jurisdictions we're not that familiar with, if there could be some hostility to us. But again, if we are compliant with labor law proactively as we qualify for the best practices under PAGA reform, this should be minimized. SB 399, we don't want to overstate what this does, and some people are maybe taking their concern about it too far, but we want to make people aware of it. The intent of this bill is primarily where a union is attempting to organize an employer and the employer holds meetings to try and convince employees not to join the union, bringing in people and requiring attendance at those. So this is clearly outlined in the bill that if an employer holds one of those types of meetings, they cannot take any adverse action on an employee who refuses to participate. But some have talked about, because the bill also talks about religious matters or political matters, how far could that go if you're having an all hands meeting and somebody brings up, a company, leader talks about, a state, the governor, the president. Is that now a political matter? Some people have said, gosh, could this even affect holding safety meetings and somebody makes some, the superintendent or foreman makes some political comment, and we don't want to overreact to it, but we need to be careful. Even holding a, Christmas party for the office, is that a religious matter thing? Or do we call it a holiday party? So again, it's there. The main point is if somebody was in a battle organization or not, and if somebody was in one of those, they need to have serious attorney oversight, because the laws are pretty clear and pretty strict now on what an employer can or can't do. All right. This next bill hopefully won't affect us much, but we need to be aware of it. This SB 988 supposedly establishes the Freelance Worker Protection Act, trying to help protect those freelancers. And when you look at the bill and then look up the definition of professional services, the link for that I included there. There aren't that many people we typically would hire. Maybe a marketing person. It talks about an HR independent contractor, person helping us with HR, graphics people, but not too much else. However, we might hire someone like that, and this gives that person a private right of action, um, as we see with prevailing plaintiff attorney fee recovery, et cetera. So they're trying to make it harder, and sadly, it's typical. They call this the Freelance Worker Protection Act, but it's actually the opposite, because what most employers, I think, are going to do is hire a firm, because the agreement has to be in writing. And so what does that look like? If it's not in writing, the employee can automatically, get penalties. But it only covers contracts with an individual. So if you hire a firm that can do that independent contracting work, this doesn't apply. So just be aware of it if you're hiring people to do some of those things, or, you might wind up hiring a firm to do that. SB 1100, Senator Portantino, thankfully he's termed out. He's the one who also tried to bring giving unemployment insurance to striking workers, which thankfully died in the legislature and was vetoed last year by the governor, same bill. And this bill is, hopefully won't be a big deal, but we need to be aware of it. We need to respond to it. And I included in italics the actual wording out of the legislation, because it's just a pain. Another well-intentioned thing. If we're doing anything, application posting, job ad, and say someone must have a driver's license, we can't do that unless both of these conditions are met. Does driving to be one of the job functions? And we have to go through an exercise of reasonably believing that an employee cannot use an alternative form of transportation. And we know that would likely be something like Uber. So if we're hiring a salesperson and, could they say, hey, I can Uber to all the places you want me to go for the same cost as it would cost mileage reimbursement? We need to have actually gone through that exercise and said, probably not. It wouldn't be comparable in travel time or cost. So this is an exercise we're going to do, and we know, for the most part, our construction workers, they're going to bring tools and, hard hats and different things to the job. And they're not going to use Uber for something like that. But again, just a hurdle to do. We need to not ignore this, because we just don't want to be at the wrong place at the wrong time and have the employee make this kind of claim. So that's it for labor. And then we move into more discrimination issues. And these claims are on the rise, both nationally and statewide. We need to be careful and aware of them. And just before we go through this, I will suggest that we should all have a consult with our labor attorney or advisor, saying, okay, under what circumstances taking action against an employee, suspension, termination, etc., could we be held in hiring? Could we be held in a discriminatory fashion, and what are the procedures we need to walk through? Because most employers that get dinged and the fines just go seemingly 50,000 and up, even for a single employee, it's that the employer took an adverse action or an employee complained and the employer just did nothing and reasonable or smart in response. So as we talk through these, I think we need to do that, because you'll see they want to try and come at us from several different avenues. And I don't think AB 1815 is going to be a real problem for our members necessarily. But as you know, some retail establishments have dress appearance codes, and there's been some question about some employees' hairstyles and being, from an ethnic basis or whatever. So this makes a small change. You can look at it. Again, if you have no dress code for the office or the showroom or whatever, you probably don't need to worry about it, but wanted to just make sure you were aware. AB 2499, again, this bill, a real mess. They gave 6 amendments and it is what it is. There are other sections of the bill dealing with certain things. When you go to it, just look at section 3 because it now gives an employee who is taking leave due to themselves or a family member being a victim of a crime. And this can be challenging because, what do they need to do? Do they need this leave to go help someone file a restraining order, to go testify in court, to do different things for themselves or a family member? So your HR people will need to clearly realize when someone is able to take this leave or not, because and there are several nuances to it, so you'll want to walk through that pretty carefully. SB 1137 and 1340 are Senator Smallwood Cuevas is a very progressive, challenging senator from basically central LA. And this first one makes it harder to just defend discrimination claims because now they talk about intersectionality of protected characteristics. So an employer doesn't need to have just made a, I don't like people of this race or of this religion or something else. They can say, well, no, it was a combination of race or religion or national origin, and we don't need you to have made the blatant statement. And also includes that now a perception. And how do you disprove a perception? When somebody claims, I think you perceived that was true about me and it was not, well, if I say no, what's the evidence? So, again, this is where we want to talk this through with our labor law advisor before this takes place and just say, okay, how do we avoid, getting on the wrong side of this deal? And then this next one, again, this is putting more arrows in the quiver of local enforcement on discrimination employment claims. The employee just has to have filed with the California Civil Rights Department, which does want to start ramping up their enforcement of discrimination claims, but they are woefully understaffed to do that. So if anybody complains to them, they're rarely going to take it on themselves. They'll just turn around and give you a right to sue notice, and there you have cities and counties, district attorneys, city attorneys who would be able to pursue that against us. So again, not to overreact to these things, but the same concept of walking through how we avoid discriminating against people will protect us from this because there could be more people after us. Okay, a few on workers' comp. AB 1239, good bill. We supported it. Just extends, we can pay. As we know, for some employees, it's really much more helpful to give them a prepaid debit card for their disability payments with addresses that change and disappear. So that's been extended. That's a good idea. AB 1870, they now require, effective January 1, our workers' comp poster to say the employee can consult an attorney, but thankfully they included that the fees will, in most instances, be paid from the employee's recovery. So an employee will understand my recovery will be reduced to hire the employee. That's not necessarily a bad thing. And thankfully, the Division of Workers' Comp did already post the form. So you can either think about putting it up now, or as long as you have it up by January 1, it is there, thankfully. And then AB 2337 by Diane Dixon, just as one of our Government Affairs Committee members, Dave Keefe, said, Welcome to the 21st century, California. Employees can now sign settlements through electronic signatures. What a deal. All right. In housing, this is more we need to be aware of, but we are in the middle of a lot of people doing legal combat. As we know, there are several parties in the housing development mix with very competing interests. The state wants to have more jurisdictions build more housing, especially for lower and moderate income people. Um, Local jurisdictions don't want to be told what to build and where to build it and what what type to build. So they're competing against each other. There are NIMBYs where local people will establish as we know, a nonprofit and fund it with enough money to get a retainer for an attorney to file a CEQA lawsuit or another lawsuit, and they can stall projects. And there are YIMBYs, some of those groups, and they're gaining some clout where they turn around and file a lawsuit wanting to try and push the project to approval or overcome the denial. And then, of course, there's the housing developers and builders we work for who are just trying to build housing. And they're stuck in some of these things. And so we have all these five people, and you will see by these bills, everybody's fighting to get more legal leverage. And unfortunately or fortunately, whichever way you want to look at it, they each got more of that leverage through the bills that were passed this year. And the problem for us is we will see more and more where YIMBYs and some housing developers are going to believe and actually probably have the legal right to say, we're just going ahead with this project, even though it was denied or CEQA lawsuit we think is, wrong. We're just going ahead with this project. And the problem for us is, of course, our bid guarantee. If a project starts and it's held up for a year, 18 months or more, just in legal issues, what happens to our bid guarantee for price? So many of our members have put, in their proposals, our bid is only good if the project starts by a certain date or the project or our work starts by a certain date. If not, our bids are no longer valid and we get to rebid the project. I think we need to not only do that carefully as well, but also with these types of projects, put in more language about if there is a delay, a legal delay longer than some period of time, our bid, our pricing guarantee is off. And you'll probably want to walk through that with your attorney to make sure, obviously, it's not just in our bid proposal clearly and precisely, but also we get that in the contract when it's issued so that we're not stuck. Because, the only guarantee through all these housing bills is there will be more litigation and it will last longer. But you can see everybody's vying for more leverage, and they got it. So the first one, AB 1886, gives the state more ability to challenge cities and counties who are not complying with their housing element law. And, the governor, yesterday is suing Norwalk. They're going after multiple jurisdictions who they believe are not compliant and are trying to force them to do things. AB 2023, this gives housing developers more tools to overcome project denials, going back the other way. AB 2243 by Buffy Wicks, this adds on to, she had some bills that talk about by right use of project. And this is, again, where a developer will say, I have a right to do this project. Nobody can deny it. It fits the criteria, and they start. And will somebody file a lawsuit and try and get the project to stop or end? We'll see how that shakes out, but it does expand previously so that they can do more of these projects nearer to freeways, in former industrial areas, and in malls. As we know, many malls are dying or dead and are being redeveloped. So there may be more opportunity for us, and that's great. But we need to be aware this is, again, the type of thing where a project could go and a lawsuit could stall it or stop it. SB 393 goes back the other way, makes it harder for private housing developers to defend a CEQA lawsuit. The law right now says you can require the plaintiff in the CEQA lawsuit to file a post bond, and you can claim it's a bad faith suit. And let's see, someone has a Q&A. We'll look at it in just a sec. So let's see, Amy, just wondering who sits on the Government Affairs Committee. We'll talk about them at the end. Good job. Thank you, Amy. Then SB 450. Going back the other way again. This is from Senator Tony Atkins, leader of the Senate. And then a bunch of little changes to zoning laws make it harder for permitting agencies to oppose housing developments. So you can see these just go back and forth. So make sure we cover our bid price guarantees in this because it's going to get stickier and more legal, I'm afraid, on some of these projects at least. And then AB 2114 by Jackie Irwin. And we need to be aware of this. Hopefully you saw the trade memo yesterday that I was at the International Risk Management Construction Risk Conference, annual conference last week, and a builder from Southern Cal, good long-term builder, does multifamily, and they'd gone over 10 years without a construction defect lawsuit, suddenly have 3. And they're thinking it's because the deadline for the required balcony inspections is January 1, and those are being done. And we knew there was a likelihood that plaintiff attorneys might subsidize balcony inspectors and get copies of the reports and say, hey, we hope this will not be a hard thing to turn around and defeat. Because again, if it's for sale, it's covered under SB 800. Even if it's apartments, there are still, negligence issues that have to be proven. So hopefully, if we wind up in one of these, especially if we're, a party to the balcony construction or related to it, we work with our builder developer clients to shut this down pretty quickly so plaintiff attorneys realize this is a losing proposition. Just because the inspector says something was out of, not built perfectly to code does not mean it is a violation or a problem. So hopefully we get there. And because people were not getting these, so that we talked about that yesterday in the trade memo, but this law allows now, instead of just structural engineers or architects, now it allows licensed civil engineers to do these inspections because people weren't having enough people available to do the inspections. So we imagine there will be kind of a rush of these trying to meet the January 1 deadline. So we'll keep our eyes open, especially after the first of the year, if these try to germinate into construction defect lawsuits. Okay. And these 2 bills, and we just want to identify Joe Patterson, Republican in the Assembly. He's been a great guy, stood up for our issues on several labor type bills, regarding housing and how this could impact us. So we appreciate him stepping in here. These are talking about permit developments, so they don't affect us directly, but he definitely stands up for housing in a smart way, a right way, and he's very, articulate, combats, does legal, legislative combat in the right way. with people. So any chance you get, you can thank Joe Patterson or support him. We try and do that. Senator Becker, SB 382. This again is a bill that went back and forth, and you can make a case one way or the other. Is this a good or a bad bill? Because what we've tried to generally be behind is a homeowner who files a construction defect litigation and gets the money and doesn't repair anything. It can help us if they have to disclose that they didn't repair what they claimed to the next homeowner. And this kind of went maybe towards that and not, and then went another direction and it landed here. If you're a electrical contractor, you just need to be aware that this bill will start a year later, January 1, 2026, and will require a seller of a single family residential property more than 3 years from original CO. Their documents shall include a provision. It may be advisable to obtain an inspection by a qualified professional of the electrical systems. And I didn't list the whole thing, but they talk about panels and things like that. So we hope this does, again, not generate much. It's going to be one of, 75 documents the homeowner goes through. The buyer goes through. Hopefully they don't do much with it, but some people might, think about it. So we'll need to be prepared if this kind of thing, again, if they have someone do an inspection, they say, hey, this wasn't done quite right or whatever, we might see some claims come out of this after January 1 of next year or 2026. And then SB 1210, this will be interesting. All utilities for new housing have to post costs of connections and connection times, timeframes to make it. Hopefully, and again, this is extended to 1/1/2026, but hopefully this could give more transparency and give us greater clarity on how long it's going to take to get all these connections done, because sometimes that can be a real problem. And for all those who do any digging excavation, as we know, the DigSafe Act, the DigSafe Alert, this bill is there's a lot of pieces to it, but it's cleanup of the original legislation with problems that are there. If you do any subsurface work, you need to review all those pieces and parts. Nothing should be problematic, but there are things like your ticket to excavate. If it expires, it says you have to stop work immediately and not start work again until it's actually the ticket is extended, things like that. So if you're plumbing, other parties that do any underground excavation, follow through and know what that is. Only one Cal OSHA bill made it through. And this is AB 1976. And on the one hand, it's delayed for a couple of years. And even then requires Cal OSHA to develop a proposal to have basically Narcan and first aid kits. On the one hand, as a societal good, Narcan makes a big difference. It can save lives. And this law, we appreciate, gives immunity to someone administering it. And we know there's some serious drug use issues amongst construction workers. The problem you can get with Narcan is it requires temperature controls for storage. That's why our typical first aid kits, it can't just work in. So they'll have time to do that. You might want to yourself, or might be have people say, hey, let's try and get Narcan on our job sites or in our vehicles or something. So it might be something you explore in the meantime on how you might do this if you want to. Again, it can really save someone's life if it's there available when they need it. And for employers with between 5 and 19 employees, 6 to 18 technically. And some of our members are that size and or suppliers. There's been a pilot mediation program for leave claims for, you see the three things listed: family care, medical, bereavement leave. And they've now made that permanent. I think it's a good idea. That people don't have to go to litigation, and it now includes if there's a reproductive loss leave claim, that can be covered by that program. So if you're in that range, know that you have that available, and it is now permanent. Contractor State License Board, obviously this likely won't matter to us, but we can know they're increasing from $500 to $1,000 the cost of work of improvement that an unlicensed individual can do. And then SB 1455, the CSLB, as you know, there's been a push to have all licensees file a workers' comp certificate of workers' compensation, even if they claim they have no employees. And that's about half of all active licensees claim no employees. So people believe there's a lot of cheating going on by that. So there are 4 current license classes that are required to do it: roofing, concrete, HVAC, and tree work. Those will remain. The idea was they were going to require every licensee to do that by January 1, 2026, and the CSLB just said we wouldn't be able to handle it. And we support that. On the one hand, we don't want people to cheat, but we don't want anyone, our members' license renewal bogged down by the CSLB delaying processing all renewals, because if half of all active licensees, that's about 110,000 licensees, don't have workers' comp, it's going to be a mess when they are finally required to. So that's pushed off to 2028. CSLB has to be reauthorized every 4 years. We support that. They got that till 2029, and now, though, federally recognized tribes can have CSLB licenses and technically could compete. And I will finish with public works projects, and let's see if there's, I think that's only, I'll just go ahead right now and say who our Government Affairs Committee members are, because we greatly appreciate all they've done. We have to walk through sometimes tedious bills. We have to talk about the political ramifications, who's opposed, who's in support, what's political fallout of supporting or opposing a particular bill, and what the bill itself does. We try to be fairly judicious on bills that we pursue. So, and we want to greatly thank John Mullen, Pacific M Painting, was our chair for many, many years, did just a great job. He had a lot of wisdom, a lot of experience. He was on a city council, so he brought a lot of great depth to it, and he really did a great job of allowing, the conversations, because sometimes you have to, you're working through disagreements, and we took the time to do that. So John has now retired from the committee this year. We wish him very well and appreciate his many years of great service. So the committee now is from Northern California. We have Andrew Sellers of Capital City Drywall, Mark Cooper of H&D Electric. In Southern California, we have David Keefe of Trilogy Plumbing, Matt Kidd of Triton Construction, Tanner Chamber of Chamber Electric, and yes, have we hit all? That's 5. Am I missing? See, I'm trying to do this on the fly here.
I think we should also acknowledge RJ too. RJ certainly helps.
Yeah, our contract lobbyist is part of that group, and yeah, So let me double check that real quick, just in case. As you know, we work all year, but then you oh, have we covered everybody? Let's see. Oops. Okay. And well, that one didn't have everybody. In just a minute, we'll get to the others. Okay. And Mike Koonsman, sorry, of Builders First. Yeah, sorry, Mike. Trying to, because Mike's all over the state, so I wasn't pinning him geographically. So it's a great group. We walk through tough issues and we come to a conclusion, and that's why we took a position on 62 bills. They were worthy of taking a position and fighting one way or the other. So, okay. Then our public works projects, we'll do a few of those. There's a best value construction contracting method that was under a pilot and is now available to all cities and counties, where county supervisors can put criteria for selecting their public works projects, not solely based on price. They can go on labor compliance and experience and financial condition and different things. So hopefully there can be more merit-based awarding of contracts, not just particular who's the absolute lowest price. AB 2705, this will affect you possibly in that payment bond insurers used to have a shorter liability for when a project ended before the labor commissioner could finally issue a civil wage and penalty assessment. Now, this moves their timeline to the same time as the employer who gets the assessment. So payment bond insurers may try to increase prices, talk about capacity, and do different things on your payment bond when you're doing a public works project. So you'll need to just be in contact with your broker and insurer about, navigating that if there's any issues. Okay. SB 1068. If you do or want to do work with the Tri-Valley San Joaquin Valley Regional Rail Authority, they are now authorized to use the construction manager, general contractor, project delivery method. SB 1162, this is one of these back and forth, strongly amended bills. And as you know, the unions have tried to make public works projects harder for merit shop contractors to compete in. And by that, they've been instituting more and more a requirement for a skilled and trained workforce, which is not required by law. But if it is, then there are certain parameters to it. And this is where, if that is in place, the contractor has to certify that all its workers on that project are either registered in a California apprenticeship program, or that they are skilled journey persons, of whom, depending on the craft work, 30 or 60% are graduates of an apprenticeship program. And so the rest of the people, skilled journey persons, means they have worked, documented enough time in the craft that they could be qualified as a graduate, even if they didn't go through the actual apprenticeship program. So this is adding requirements to that. You could just declare you were that way now. You have to give the full name of the employee, their apprenticeship program name, location, and graduation date. So it's going to be harder or more work involved in that. The penalties are significant. So if you're in a project that requires skilled and trained workforce, make sure you cover all your bases. And even union contractors sometimes struggle to meet the actual graduate percentage requirements. So make sure you're covering all that and have all this information. And finally, lastly, Senator Caballero, as the unions have also tried to push out as best they can private labor compliance entities to do labor compliance on public works projects, so that more would be done by and or have a free view of the labor management cooperation committees, LMCCs. And now they can initiate a private right of action against someone who has a conflict of interest. So that's going to make it even harder. And you see the exceptions are long established private labor compliance groups, the four listed there. So we have hit our end of our journey here. It was not as bad a year with as many terrible bills as before. Again, great thanks to all our members who contributed to our PAC. We keep moving the legislature more common sense, business friendly. Thanks to our Government Affairs Committee, RJ, our team, we've done very well. And we do want to thank our coalition members, Cal Chamber and others. I'm on a couple of their committees. We work well as coalitions to push these things and try and make life better for all of us. And PAGA reform was a great example of that. The coalition was led by Cal Chamber. People have put up $12 million to force put an initiative on the ballot that we didn't have to vote for because it forced the issue and got people around the table, and we got significant reform. So with that, are there any final questions or comments anybody has? Hearing none, again, we encourage everybody who can come to our anniversary celebration November 21. It's going to be a great time. And, working, living, managing a business in California is hard. It's nice to be able to, once in a while, celebrate that, we're here and we're making it work. And we're actually, some things are starting to turn around. We can have a better future for that.
Right.
So, Cheryl, you have any final thoughts?
No, I was just going to say that thanks, Bruce, for adding that in. And we look forward to seeing many of our members there down at Pechanga. It's a beautiful facility. And we'll be also celebrating Bruce and his 25 years of service to Housing Contractors of California. He's been an incredible resource for us. And we really want to celebrate him and all the things he's contributed to our organization. So thank you in front of everybody here too, Bruce, but we look forward to celebrating you on the 21st as well.
Okay. Thanks, Cheryl. Well, thanks, everybody. Have a good holiday season coming up, and we'll be coming back at you again.
Okay. Have a good day, everyone. Bye-bye.
Thanks, everybody. Right. There we go.